Hello, welcome to Exploring Parallels in the Music and Publishing Industries. This is my capstone seminar presentation for the Master of Arts program in Marketing Communications Management. My name is Janel Kane, and today I am going to discuss with you the parallels in the marketing and publishing industries. First, I'll talk about the background, my approach. I'll discuss the literature that I reviewed and the solutions I came up with. After a prolonged period of stability in both the music and publishing industries, the internet has been a real game changer. Digital media can be copied without loss of fidelity, and it is not exclusive. So if I share a copy of a music file online and you download it, I still have the copy on my computer. Now you also have a copy. It is no longer exclusive, the way a CD or a hard copy book would be, where I could not keep the same copy in the same condition and transfer the copy to you. So that was a big change. The publishing industry has had very little change since the Gutenberg press. The music industry, on the other hand, has had steady technological progress, but it has been more of a quality race, better quality recordings. The music industry hasn't seen a change on this scope as transformative since the introduction of the phonograph and the first recordings ever made. So it's very significant. Digital distribution is a big challenge also to the traditional market intermediaries. They previously enjoyed a monopoly over physical distribution channels, bookstores, record stores, radio airtime. Unless you were using a traditional path to market, these roads were traditionally closed to you. You could not get into a bookstore unless you were published by a big publisher. Amazon, on the other hand, anyone can publish a book on Amazon. iTunes, anyone can publish a song for download on iTunes. Pandora, Apple Music, maybe a little more complicated, but you can be an independent and get enough attention that Pandora might put you on. That is curated, but it is no longer necessarily a closed path to market. Digital media consumers, another important change is that they no longer own their own media. So physical media was exclusive. It couldn't be copied without loss of quality. A mixtape was not the same as the store-bought cassette. It allowed a thriving secondhand market. If I sold my cassette, I couldn't keep the same quality copy. So it was exclusive. So you had the first right doctrine, first right of sale. The author was given their royalties at the initial sale, and now that becomes a private commodity owned by the end consumer to do with as they please, and they can sell their secondhand copy because it doesn't infringe the copyrights. The author has already been given credit for that. Digital media, on the other hand, is licensed rather than purchased. When you purchase a piece of digital media, you do not own that digital media. You have purchased a license to use that digital media. It's an important distinction. And that means that the person you purchased it from retains some control over it and what you can do with it. Amazon books that you buy for your Kindle, you cannot go and resell them to someone else. You can't. There's some lending that used to be available on Nook, but you can't typically share an ebook with someone else. So it's a little bit of a change, or actually a very important change. My theory, and the reason I approach this topic this way, I believe that even though the music and publishing industries appear to be distinct and separate industries, They are, in fact, so closely related they should actually be considered part of a larger category of cultural industries. And the threat that they face is a larger threat. The same threat is facing all of those industries. Um, so, therefore, addressing those issues requires getting to the root causes at that industry category level. I think this is significant to anyone that's interested in working within these industries in any way. Old market players used to provide value to creative authors. The trade-off for their rights was the path to market. The old players no longer control the path to market, so they don't offer the same value to the artists anymore. Distribution was also something that was held in monopoly by the old market players. They had extreme vertical integration where they controlled the entire industry vertical, more or less, and that power has been broken up. But new business models to deliver the digital distribution channels have gained that power. So the power has transferred from one monopoly to another. And because of that, artists struggle to see remuneration for their efforts. They have to fight piracy on their own. They also have to take on a greater responsibility for those upfront costs and investments in bringing their work to market. It is definitely shifted the balance of power within the market. So, thesis. I began by gathering all credible sources that I could find using academic databases to find anything I could related to the music industry, the publishing industry, copyrights, the transition to digital media, anything that related to comparisons of the music industry and publishing industry. I gathered everything I could find. I then culled the sources that were not credible or peer-reviewed or relevant. I organized a broad selection of quantitative and qualitative research into, I found 4 categories where publishing and music intersected. The history of these two industries, the legal issues that they face, the technological advances in these industries, and the business models that have developed as a result. So I explored those 4 areas. Literature. So again, 4 areas of interest: historical, legal, technological, and business models. Quick introduction to intellectual property rights. The music and publishing industries are able to function because of the protections that we afford to intellectual property. And that is anything that is the result of creativity, which can be, copyrighted means it's in a fixed media of some sort. So books, recordings, film, photographs, etc. can all be copyrighted. That allows, by protecting unauthorized usage of these creative works, the originator, in the original intention, the artist, would be able to profit from them and therefore have an incentive to create more things. And other people would have an incentive to be creative because they would be able to be rewarded for their creativity financially. So that is the purpose of rights. The historical development of these industries is very similar. Not a lot of change until after World War II. After World War II, things really blew up. Demand for entertainment was at an all-time high because there was a growing middle class with disposable income and leisure time to enjoy entertainment. Recorded music was very popular. So because the creatives would trade the rights to their creative work to an agent that would invest the upfront cost of production. In the case of a recording, a master recording that would be the basis for all reproductions that would be sold. In the case of a book, the original manuscript of the book would need editing, books would need book covers, albums need to be pressed and taken to market. So the agent, in this case a record label or publishing house, would assume those upfront costs. They become the rights holder, they hold on to those rights and are able to profit on that investment by selling reproductions of that original work. First they recoup their investment, and then according to contract terms, the remainder is shared then with the creative originator in some form. Often they get an advance up front, a small advance, and then once the costs are paid back, then the profit is shared in some form. Rights holders are able to mitigate their risk by developing a portfolio of rights and taking advantage of economies of scale. So by having many records on the label, if several of them don't succeed and don't make any money, then perhaps one or two will be very successful and offset those costs. So they mitigate their risk that way. And by working in large scale quantities, they're able to produce physical goods at a cheaper cost overall. So after World War II, the music and publishing industries consolidated into the hands of a few very powerful rights holders with large, deep portfolios. So they had a lot of power. They were able to build large networks and make investments. And so that allowed them to control the entire industry vertical, from production, which was often done in-house, distribution. They had enough power that they could dictate the price at retail and dictate where different products would be displayed in stores. Pardon. These rights holders have a reputation for treating creatives like sharecroppers, and what that means is that artists would be required to shop at the company store, so to speak. So the record label would sign, for example, a recording artist to record an album, but they would have that album recorded in their in-house studio and would control every aspect of what the liner notes looked like, what the design looked like, how it went to market. But the artists would then be responsible for those upfront costs in that investment. So the record label would charge for those expenses against the income of the album. By having the production done in-house, an album could be very, very expensive to make. And until the record label had recouped those costs that it set, there would be no payout to the musician. Many times musicians make no money whatsoever off the sale of recordings, albums in the past, and now downloads. Traditionally, authors make all of their money, almost all of their income, from other rights that allow them to do concerts. And I'll talk on the next slide about those rights just a little bit more. So the legal landscape that these industries work under Copyright law, as we commonly understand it, is actually a really complex patchwork of laws, decisions that came about because of civil lawsuits, actions handed down from the uh, Copyright Office and the Copyright Royalty Board, which are regulatory agencies that oversee some copyright issues. So it's actually a very complex, very messy set of laws and difficult to maneuver. It protects a rights holder's ability to profit from the work by not allowing anyone to make copies. That's infringement of the rights. It gives the rights holder a legal basis to seek compensation if someone is making copies. They have a basis to sue them. And we refer to that unauthorized reproduction of copyrighted works as piracy. Even if it's digital media and you're uploading something and someone's downloading it, that is considered piracy. An important quirk to understand about the music industry in particular as well is that music rights are bifurcated, meaning they're cut in half. There are two main categories of rights for music. Well, with any creative work, there might be different things that arise. Even with a novel, you might have a film adaptation, for example. Much rarer. Most copyrights for books are very simple. It's just the copyright for the book. That's the only revenue stream that is available to most authors. In music, however, there are two primary rights that go with almost any piece of music automatically. That is the performance rights for the songwriter who originally created that work of music. It is published, and the originator of that published piece of music has the right to perform it, or can sell or trade the right to perform it to another musician. But that is the performance right. And then there's also the right for the sound recording. So, and that is a much more limited right. So you have a particular sound recording in the record studio, for example, the record label's studio, where you make a commercially available recording that you then reproduce and you sell online. Maybe you sell in big box retailers or other locations. And so you sell these albums, and that is the right to just that recording of that piece of music. It is a reproduction of that piece of music. So that right is only for that particular recording. And if someone creates a different arrangement, has the performance rights, and performs the music, and it is recorded, that is a different recording. And so it is not under the same recording rights as the music industry, as the record label's rights. It's a different recording. Traditionally, the sound recording rights would go to the record label, and the performance rights would belong to the songwriter. And that was what allowed the musicians to keep the revenue from live performances and concerts, and therefore that was the source of their revenue. Whereas the sound recording rights were predominantly went to the recording industry, and the the musicians saw very little of that. So the technological advancements that hit these two industries at the advent of the internet age, home computing and the internet were just transformative for every industry and every facet of life. And then additionally, improvements in connection speed, bandwidth, various other technologies all multiplied that effect. So in the music industry, that was the MP3 and the iPod. The switch to digital began with compact discs, but those files were still too large and the internet was too slow to really make any use of that. So it was the MP3 that compressed music into such a much smaller package and as well as increased speeds on the internet that allowed for everything to just come to fruition with the beginning of Napster, which launched in 1999. So on the publishing side, that was PDFs, the portable document format. It was the precursor to other ebook formats that are in use today. But the publishing industry lagged on adoption a little bit. They were not as quickly adopted because predominantly that required the use of a specialized e-reader, and that took time to develop. So ebooks were not quite as quick to get into major production. The smartphone changed that considerably. Many people read on their phones today. Okay, so and then finally, the last area of intersectionality was new business models, and both the publishing industry and recording industry have reacted in many of the same ways. On the demand side, we see subscription services quite often, and those can provide an alternative to piracy in many cases for people who are less apt to piracy. There are different tiers usually in a subscription service, free and ad-supported, which is where these services actually make the majority of their money, is from ad revenue. And then there's also a premium, ad-free, for people who are particularly sensitive to ads and are willing to pay significantly more. You can have a premium service. And then we also see interactive and non-interactive, and those will determine how authors are paid for royalties. So an interactive service allows someone to pick the exact piece of music that they want, the song, the author, and pick that exact song to listen to. That requires special negotiations with all the rights holders involved to produce that piece of music as a digital media. Non-interactive services, on the other hand, do not allow you to pick the exact piece of music and author. An example of that would be Pandora, where you can pick authors like somebody, and you might get one or two songs from the artist that you wanted, but you'll also get a dozen or so other artists that are similar, but you didn't choose yourself. So that would be a non-interactive one. On the supply side, we see changes happening over distribution. Retail stores bookstores and record stores no longer exist. They have been ceded to big box stores, so Walmarts, Targets, and because they do not deal exclusively in media, they do not rely on the media for their revenue. So the record labels and publishing houses no longer have the same power over distribution because they're not as needed. They don't have as much influence, so that has been a change. Digital distribution also I've discussed is also a big change, and that has become dominated by a small number of channels, again becoming monopolies. On the over creative interactions, traditional contracts don't offer the same terms. So if the value of a recording contract was the path to market, and that path to market is no longer dominated by the record label, and the record label is perhaps no longer providing as much support and development for new artists, but taking the same cut, they're providing less value for the same money. So it has become more expensive for artists to be in recording contracts for that reason. And then also many entities are doing what's called 360 deals, where they reach into revenue streams that traditionally belong to the artist. The performance rights I mentioned, merchandise, for example, where the and this might not be a record label. It might be a concert promoter who also has the ability to, has enough connections to offer some of the other services of a record label. So those are some of the changes we've seen on the supply side. Very similar. Don't see 360 deals in the publishing side yet, but it might just be a matter of time. Part of the reason, however, would be there are not alternative revenue streams. There are only the books, really, for the most part. Alrighty. So on my thesis, I believe that the available literature clearly shows many very close correlations between the music and publishing industry. Historically, they developed in tandem, pushed by the same forces, responding to the same market pressures, developed similarly organized industries historically. The legal precedents that give these industries power, the intellectual property rights, are identical. It's the same set of laws, just different layers of the same general concept. The technological advances are based on the same compression technology and have a very similar result. And these industries are responding the same way to challenges. So I believe that there's ample support to the argument in favor of classifying the music and publishing industries as cultural industries for the purpose of seeking viable, sustainable solutions to these industries' challenges. So some actionable solutions depend on the different constituencies. So one constituency is the intermediaries. The constituency includes traditional rights holders, record labels, publishing houses, but also the new wave of distributors. So this is anyone involved in bringing creative work to market, but not the artists. Society has a vested interest in these cultural industries continuing, but it should not mean protection for one individual business model or company, because that would be at the expense of competition and progress. The solution for intermediaries is modernizing and simplifying copyright law with complete overhaul. These laws are very complex, needlessly complex and convoluted, difficult to apply, difficult to understand, and interpret. And therefore, modernizing and simplifying these copyright laws would be very beneficial, particularly to the intermediaries, determining where different rights leave off and different rights begin. For the creative class, this constituency is a disparate group of decentralized actors that work in projects. So a book is a discrete work in a project. One author does his or her book. Maybe there would be editors involved, other people involved in a discrete project. Same with a record. You have various musicians. You might have producers, sound technicians, but they all produce an album, which is a discrete and separate, distinct project. But because they work in these small groups and it's project-based, they don't have a lot of power to organize. They're definitely have a power disadvantage against the big players. With collective bargaining, a sort of collective organizing, it would allow for artists within industries to negotiate with their intermediaries more effectively, for authors to negotiate for changes with Amazon, for example. could happen with collective bargaining. And then also across industries. So if a copyright law reform movement were to take place, were to pick up steam, a collective group representing the artists would be very beneficial to represent creatives in any kind of discussion over copyright overhaul. They should definitely have their interests represented. The next constituency that is concerned with the recording with the cultural industries would be the public. So society has, as a whole, has an interest in cultural industries. Arts and cultural achievement are a public good. It makes society a more beautiful place to be. And then the public is also concerned about employment and these jobs continuing. So these industries continuing so that they continue to employ people. Individuals have an interest in how they access the media, and they also have privacy concerns. And also this group is very large, very decentralized, and it can't be acted on and influenced directly. You can't call up the public on the phone and have a chat. So the only way to influence these folks is through various media, doing public relations, and so on. Solutions for this group. An industry watchdog group could advocate for the privacy and other rights of this group against, for example, intermediaries. In the case of, for example, Apple Music, there is some rumor that Apple Music seeks out music files on your hard drive, and after finding the closest match within Apple Music, deletes files from your hard drive. And so something like that would have very real privacy concerns for people who don't want their files deleted from their computer. Some of these files might be CDs that they purchased once upon a time and then uploaded to their computer, and they legitimately own that and should be allowed to continue to legitimately own that rather than have their property taken. Illegal search and seizure or unreasonable search and seizure is something we're protected from by the government, but we're not protected from a private company doing that to us. So an industry watchdog would be very beneficial for that. And then also a federal agency that could oversee and mediate copyright overhaul would also be in the public's best interest. And I'll come back to that in a minute with another slide. Discussing these solutions just a little bit. Copyright, I've talked extensively about the complexities of copyright law. It's very complex. It's not very effectual at coping with modern copyright issues, especially piracy. However, the legislative climate's not really conducive to pushing laws through in any meaningful way and actually having something signed into law. And the current political climate, there's also a strong vocal sentiment against federal oversight in any form. And so that would trigger some probably vocal criticism. Collective bargaining for creatives. The internet was really promised to open up the doors to creatives and democratize art, the arts. But we've really seen power transfer from one group of monopolies to another. Individual creatives also have limited access to information and legal recourse. So a large publishing house would have more resources to go after book piracy than an independent author would. And it is the author's responsibility or the rights holder's responsibility to pursue infringement. So it's very, very much more difficult for individuals to access that kind of legal recourse. Additionally, if it's not piracy, if legal recourse is needed to deal with an issue with an intermediary, these intermediaries are much larger, with much more deeply funded, and access to cadres of lawyers, and can bury someone in paperwork. It's very difficult for an individual artist to seek any kind of legal redress to an issue in the courts against a large intermediary. And some collective organization could also help some of these groups pursue some collective action. So some of these smaller organizations do exist, but to organize a large group of very different interests, different opinions from people, and geographically as well, across different industries, it's just such a monumental task that I don't foresee it happening. Even if it would be a very powerful tool for authors. For public outreach, I've already discussed the public is too large and too different to be acted on directly. But public opinion is very important to the cultural industries, because these industries depend on the public to consume digital media, but also the public's opinion of these industries has a large effect on how successful they are. So the opinion of the value of digital music, for example, is not considered to be very valuable by most consumers, because they see a single song as being very cheap. Producing a digital recording, it can be done with the push of a button, so there's no incremental cost. It's very, very cheap that way. And they also don't own it, so they don't feel much investment in it. It's licensed in many cases. So people don't necessarily feel the value in cultural enterprises, and that influences whether or not they demand it for free, or whether they're willing to pay for it, or whether they pirate it. PR campaigns that would help close the value gap would go a long way to improving the outlook for these industries. But doing something like this would require manpower, funding. Someone would need to lead the effort. And there's no entity today to do that. Another solution I suggested was industry watchdogs to look after the interest of the public. Consumers are no longer owners of the media they purchase. They have privacy concerns. Some intermediaries use predatory behavior, such as price manipulation. There have been class action lawsuits against Apple Books, for example, for price fixing. And they're also concerned about the loss of jobs in the economy due to digital transition. Many digital jobs, for example, iTunes, to run iTunes, might take several dozen people pushing buttons, whereas the old form of distribution would take tens of thousands of people selling records in record stores all over the country. So the nature of these jobs have changed. The nature of these industries have changed the economy. So there's some concerns there, some real concerns that the public has. Having industry watchdogs would help restore some public confidence that these intermediaries are playing by the rules and are being made to play fair. And that would also, I think, affect the value sentiment, that value gap. And then, again, if copyright reform is ever taken up, consumers are stakeholders, and they need to have a seat at the table. And watchdog groups would be able to fulfill that role and take a seat at the table to look after, make sure the interests of the public are also considered in any copyright reform. Again, though, however, this requires organization, administration, and funding, and those are the keys. So finally, government oversight. All of these other solutions have a common flaw, and that's that they require administration and funding and people to organize and see them through. The arts are a hallmark of an advanced society, and we want to value that. So a move that would be a very strong message about the importance of these industries within our society would be to create a Department of Culture, a federal agency to oversee issues related to these cultural industries. This would give that administration and organization for all these other suggestions could fall under this umbrella of this Department of Culture. It would help effectively mediate between all the constituencies that could potentially be stakeholders in copyright reform, should that ever happen. However, again, insurmountable legislative hurdles makes this nearly impossible. And also in the current political climate, there's a strong sentiment against federal oversight in any form. Creating a new federal agency would absolutely create very vocal denunciations. So, recommendations. There's a lot more research that can be done on these cultural industries. I believe that these effects spread into other cultural industries such as television and feature film production. All of these have been changed. Every form of communication has been changed by the advent of the internet, the rise of the internet, and different technologies. So more research should be done into media piracy, how we can close the value gap, how we can end media piracy, and make sure that artists and authors are appropriately compensated and incentivized to continue to produce. And greater study can go into the conditions for the creative class altogether. You know, how what is the state of affairs for the creative class? Actionable things that can begin right away. Powerful intermediaries are flirting with conditions right for a class action lawsuit. In particular, one example I can think of offhand would be Amazon Kindle. Amazon Kindle publishing does not do any sort of plagiarism checks. There have been numerous instances of people taking entire books without even changing the cover and the author's name on the cover, and then just republishing them on their own account with their own name and skimming some of those sales away from the legitimate author. This requires that these authors take action themselves to order these be taken down. This creates what could be potentially secondary liability for infringement, where Amazon is not taking due appropriate action to prevent the infringement of copyright. We could also begin informal grassroots organization of creatives immediately, because that will take. So in conclusion, the last 20 years have witnessed complete transformation of human communication based on 4 criteria that I looked at where cultural industries intersect. I really believe that the recording industry, the music industry, and the publishing industry, as well as several other creative industries, should really logically be considered part of a larger cultural category of industries for the purposes of addressing concerns. And thank you very much. I hope that was informative, and I appreciate